Hello, everyone, and welcome to Florida Divorce 101. 5 considerations you need to be thinking about if you're planning on getting a divorce or you're even thinking about getting a divorce here in Florida. So, this is put on by DCE Law. I am the owner and operator of DCE Law. I am Deborah Sermonaro Eldridge, and I'm an attorney licensed here in the state of Florida. I have 28 years of experience in trial work. A good majority of that concerned family law or concerns family law and litigations related to juvenile dependency, which pertains to children's rights. So with that in mind, you're not here to just listen to me. You want to see and hear about those things that you need to consider if you're planning on getting a divorce or you're even, again, thinking about it. So let's take a look at the PowerPoint. And in looking at the PowerPoint, I just want to make sure, double check one thing. Because we're not yet live on Facebook. I knew something was up. There we go. Now we're live on Facebook. And here we go again. The little nuances that we have to learn regarding Facebook and streaming live to social media. So I just introduced myself. I'm Deborah Sermonaro Eldridge, the owner and operator of and attorney of DCE Law. So you're here because you want to know about the considerations before you go ahead and file for divorce. So we're going to go ahead and review those today. With that in mind, one of the first things I do, so consider this is like an initial consultation. This is basically what I would do and the questions that I would ask a client who comes to me for an initial consultation. It's also the general information that I would provide to the client as well. Now, obviously, some information would be different because of whatever their circumstances might be. Everybody's circumstances are a little different. But let's start with questions that you need to actually ask yourself if you're thinking about divorce. And the biggest question is why? Is it finances? Is it a matter of safety and quality of life? So there are a lot of things that you need to sit down and kind of think about and put into perspective. And the reason I say this is because, trust me, it's not a picnic out there. So you really want to think if you have a history with somebody and it's a good history, not an abusive history. I'm not going to sit here and say if you're in an abusive relationship or a trauma bonding or toxic relationship that you should stay, because no, I don't think that anybody should stay in that situation. But nonetheless, these are the considerations. So first, start thinking about why. Why are you even considering divorce? Once you've gotten past that, you want to start thinking about your financial situation. I know that a lot of people will stay in an unhappy situation because they're fearful of what might happen financially. And if they're fearful of what might happen financially, then the big concern becomes, how do we handle that? And just minimize this. So how we handle that means that, we tell you the steps and what you can prepare for after the divorce from a financial standpoint, depending on many factors. So is it a matter of safety and quality of life? Again, going back to that idea of the toxic relationship, if it is a matter of safety and a matter of quality of life, then you definitely want to move sooner rather than later into the realm of separating yourself from that situation. Even if you're not immediately getting divorced, separating yourself from that situation, because your safety, and if you have children, your children's safety are of paramount importance. So is it just not working any longer? Sometimes relationships just run a course, unfortunately, based on whatever factors, and it's just not working any longer. And maybe it is a mutual decision to get divorced. If you have children, how are you going to work out time sharing? And we're going to talk about how the court views time sharing here in the state of Florida. How long have you been married? We need to know that information. And then finally, what is your motivation for change? What is the catalyst that's moving you forward to actually make that change? So 5 steps to prepare you for making that decision. We're going to talk about how Florida views divorce. We're going to talk about the financial aspects of divorce a little further. We're going to talk about what happens when children are involved, how you can verify income and what qualifies as income, and then talk a little bit about what your future might look like after divorce. So how Florida views divorce. Florida views divorce as a no-fault state. And what that means is the court is not going to make a decision that the divorce is based on one person's conduct versus the other person's conduct. That's not to say that if somebody is involved in an extramarital affair, that doesn't come into play, but it doesn't come into play in the reasoning for the divorce itself. So we are no fault state, so we don't look at divorce from a blame perspective. So when you file, we file with the terminology irreconcilable differences. That's the terminology that we use, that we've always used, and we continue to use that language. You start with the idea when you go into a divorce that everything is divided 50-50, even time sharing. So what that means is there is a presumption that all of the assets and liabilities that are a result of the marriage or that you presently have during this time is to be split 50-50. Now, if you have a prenuptial agreement, then that may change the terrain, but it depends on the language. And we're not going to get into the specifics of prenups because they're tailored to specific situations. They do have a length of time after which it's hard to maintain what is wanted out of the prenup, but for all intents and purposes, generally most marriages at a certain level do not have prenups involved. If a prenup is involved, that changes the terrain, and that would be specific to that particular marriage or dissolution of marriage. So with that in mind, we have three types of divorces, what we call three types. And basically what it really means is it's three different types of filings, because when you file for divorce, you can file in one of these three ways. You can do what's called a simplified dissolution of marriage without children. You cannot have children to do a simplified dissolution of marriage filing. What that means is that you and your spouse agree on all the terms of the dissolution of marriage. So you're getting divorced, you agree how everything is going to be split, you enter into an agreement, you fill out the paperwork, and you jointly go down to the clerk's office and file it because it has to be notarized and filed in that way. I'm not going to get into e-filing right now. That's a whole separate issue. And that's a requirement that we have as well. So the other option is an uncontested dissolution of marriage with or without children. Now, when I say with or without children, when we use the term uncontested, we really mean we're looking at you have children, but you are agreeing as to all of the terms of how the divorce is going to take place, from time sharing to child support to alimony to division of assets and liabilities, all of that. If you have a business together, how that's going to be resolved. All of those things come into an uncontested dissolution of marriage. The only way you have an uncontested dissolution of marriage is if you have a signed marital settlement agreement by both parties up front. So that's basically a settlement agreement with regard to your marriage. And oftentimes what will happen is one person may go to an attorney, the other person may go to an attorney, and the attorneys resolve the matter. Or one spouse goes to the attorney, pays for the services of the attorney, and the other spouse says, you just pay for it and get everything that we decided in a marital settlement agreement, and then I'll review it and I'll sign it. Or I'll have I'll pay an attorney to help me review it and sign it. Now, contested divorce means that the other party is not agreeing to anything. And if the other party is not agreeing to anything, that means that you are actually going to file to get divorced, but it's going to be a longer process to get from point A to point B. And it's going to be a contested process because there's a lot more involved and it is much more expensive. So your most inexpensive options for getting divorced are going to be a simplified dissolution of marriage where you both agree and you file as a simplified dissolution of marriage because the filing fee is different, or you file as an uncontested dissolution of marriage and the filing fee is less because we don't have both parties having to pay a filing fee. And that's an uncontested, that's less expensive because you have basically everything done. Then we have the contested dissolution of marriage, and that's where things really get expensive. So just so you know, those are the different forms that we use for a contested dissolution of marriage, uncontested, and simplified dissolution of marriage. So with that in mind, let's go ahead and let me just, there we go. So you all can see me. So let's talk about three main categories of financials, because that's always a huge concern for everyone, the financials. So when we talk about financials, we're talking about three particular categories: assets and liabilities, alimony, and child support. When it comes to your assets and liabilities, you have vehicles, you have homes, you have other real property, perhaps. You have jewelry, motorcycles, RVs, artwork. I mean, boats. It can run the gamut. I've had clients that have all the stuff that we have to deal with, and then we have clients that have just a few things to deal with. So we're going to talk about that and those three main categories coming up. Then we have alimony. And how is it determined? I'm going to go through that in just a minute. And then finally, with regard to financials, child support, because if we have children involved, very important, you want to make sure that you're taking care of them. And what's really interesting with regard to children and child support is that the child support under the statute inures, and the case law inures to the child. In other words, it's for the benefit of the child. The parent cannot actually waive child support for the child, just so you all know. Now, that doesn't mean it can't be reduced based on different calculations or the way you're going to work certain things, but it cannot be waived, because the child is entitled to that money, and it's for the child's benefit. In other words, to be able to provide this similar lifestyle that the child had when the parties were actually in an intact marriage. So with that in mind, let's talk about assets and liabilities now. So when we talk about assets and liabilities, you're talking about the idea, again, of 50-50. So we always start with that presumption of 50-50. You're going to see that time and time again in the family law arena. But from that 50-50 understanding, we then have to look at what is a premarital asset or premarital liability. Did you come into the marriage with student loans or significant debt that it was yours prior to the marriage and the spouse shouldn't have any responsibility for it? Did you come into the marriage with non-marital assets that have not become marital? In other words, maybe you had a trust that a parent set up for you at one point in time, and that trust is never changed. It's just sitting there, the money's sitting there, and you haven't provided or put any of your income into that trust. It's just set up. Or maybe you had a house somewhere that is considered a non-marital asset or premarital asset because of the fact that you had this house prior to the marriage. Then we have this understanding of dissipation or waste. Now, it is not an easy task, to be quite honest, to prove dissipation or waste when it comes to marital assets or liabilities. So what that means is that oftentimes if somebody has a significant addiction, or they are involved in an extramarital affair, then what we do is we can look at the money that has been spent on that addiction or affair, and we can make the argument, it's not always well taken, but you can make the argument that based on that conduct, especially if it's egregious, which means really bad, you can make the argument that because one party increased liabilities based on that inappropriate conduct during the course of the marriage. And just so everybody knows, in the state of Florida, adultery is considered a first-degree misdemeanor in the state of Florida. So just so you all know. And so with waste and dissipation, you're looking at that, you're saying, okay, we have these additional $50,000 in liabilities because so-and-so spent this money on their mistress or paramour during the course of the marriage, or they spent it on these extracurricular activities that unfortunately were the result of an addiction, whether it's gambling or drugs or alcohol or whatever it is. And as a result, we now have $50,000 in debt that we wouldn't otherwise have. He or she should have to take that debt. It's not fair that me as the non-contributing spouse should have to absorb that. So that's what we look at also with assets. Or you look and you say, okay, I want them to take the debt, or you're looking at how they dissipated assets. They dissipated money in an account. Say you had, $100,000 in an account and they dissipated that by $50,000. Your argument is going to be, it needs to be offset by other assets because that was, again, for an inappropriate purpose. Let's talk engagement rings. Engagement rings are a very interesting thing in dissolutions of marriage and just in marriage in general. The engagement ring that you receive, let's say this is an engagement ring, it's not, but let's say this is an engagement ring and you receive this ring in anticipation of marriage, right? You become engaged. If you don't get married, the case law says you have to give it back. Unless you can prove that, again, you've got emotional damages or something else related to the breakup. So you have to give it back. But if you get married, because it is a premarital asset, you get to keep the engagement ring in the divorce. Just an FYI. So other issues that come up a lot, and I've had to deal with, family heirlooms, very important, right? I mean, let's say that you were given jewelry that your spouse inherited from their parent or their deceased parent, and now that's a family heirloom that's been passed down from generation to generation. The courts have a difficult time with that, but generally they're going to err on the side of being conservative, because is it fair if you're getting divorced for you to keep that family heirloom? And if it's worth significant money, then we might have to offset it with a different asset. Special honors, collections, awards. I could tell you stories upon stories of situations, but I will tell you this also. Judges do not like, if you end up going to court, when people withhold things that have sentimental value to the other party, because it just makes you look like you're being mean, and there's no necessary reason for it. So that's how the court looks at that. Let's bring you up to alimony and child support. So when it comes to alimony and child support, alimony is based on need and ability to pay. Child support, basically the same thing. So when we're determining alimony, we have to look at the lifestyle that you led during the course of the marriage. So we have calculations that we go through. You have financial affidavits that you have to fill out. There's a lot of work that goes into getting all the paperwork together initially just to file, but then also during the course of the filing, if it's a contested dissolution of marriage. So it's based on need and ability to pay. Well, you may need $2,000 a month, but the other spouse may not have the ability to pay $2,000 a month, or you may need $5,000, but they might not have the ability to pay. We don't want to put them in the poorhouse. The court doesn't want to put them in the poorhouse anyway. You might want to, but the court does not want to. And then it comes to child support. So child support is based on statutory guidelines. There are calculations that, as your attorneys, we have to go through and complete. And once those calculations are complete, they are based on your income. And there's not a lot of wiggle room with regard to this is what it is. Now, if in fact you are going to have a true 50-50 split of time sharing with the other parent, then that child support calculation goes another step further. And then we figure out what the difference is between what one parent owes and the other parent knows, subtract that, and then that's the amount that the higher earning parent would actually pay as child support. So it can differ a little bit, but not necessarily significantly. And again, it depends on that 50-50 time sharing split. And with regard to that, we're going to touch on that in a minute with regard to custody. And then the prenups, of course, language with regard to prenups could make a huge difference when it comes to the issue of alimony. not child support, because again, the child support is a right to the child to be kept in as close to the standard of living as the child had during the course of the marriage. That's why it's based on the party's income and other aspects, including daycare, whether they were in private school, and also health insurance cost as well. So the prenup, when it comes to alimony, can have a significant effect on alimony in any amounts, because the prenup is a separate contract that's entered into in anticipation of marriage. And once that marriage actually happens, the prenup is solidified. So brings me to another real quick aspect so that everybody is aware. In the state of Florida, and probably every state in the United States, marriage is considered a contract. So it's actually a legally valid and enforceable contract. That's why if you cheat on your spouse in the state of Florida, adultery is considered a crime, because you have entered into a contract with your spouse to have this marriage with them, not with anybody else, with them. And therefore, the idea is that you respect the bonds of marriage between the two of you. All right, next. Custody of children. Big issue, of course, if you do have children. Time sharing is the term of art that we use here in Florida. So time sharing, not custody so much, but time sharing, is presumed to be 50-50, and that's the current preference. Now, a long time ago, there were chain differences where it wasn't presumed to be in the best interest of the child to have a 50-50 time split, and it's not always in the child's best interest. I have never agreed as a parent and divorce attorney with the 50-50 split, because I've seen how hard it can be on children, but nonetheless, that's what the court looks at, because the idea is that each parent, if they're responsible, has a right to be involved in the child's life or children's lives to the extent possible. Best scenario, you guys have a good relationship, regardless of what's happened between the two of you. You have a good relationship for the benefit of the children. And sometimes it happens immediately, sometimes it takes time, but getting to that is always going to be best for the children. Now, options. You can, if you are actually going with the 50-50 split, you can alternate on a weekly basis. You can alternate with one parent having the child Sunday through Wednesday and the other parent having them Wednesday through Saturday, or alternating on exchanging on Saturdays or Sundays. There are different ways you can do the 50-50 split. If it's not going to be a 50-50 split, then what I always recommend is 2 days during the week and every other weekend. And that works out well for the children, only because it gives them the stability that really they need growing, and knowing that they're not having to flip-flop back and forth from one home to another. So it depends, of course, on your situation with regard to the 50-50 split as well. If in fact one parent is not able to care for the children, it doesn't matter how much they want a 50-50 split. If they are not in a mental or emotional state to do so, then it's not in the children's best interest. Can you all agree to something else later? Yes, but at the present time, you have to look at what is in your child's best interest. Again, everything's going to depend on every given situation. One parent can be named the primary residential parent for school purposes with regard to even a 50-50 split. But outside of that, it does not mean that they have authority over the other parent in decision making. When it comes to the children, in a true shared parental responsibility situation, both parents are involved with raising the child and making decisions, even when it comes to academics, health, and extracurricular activities. And then finally, we are looking at other options, which would be sole custody. Sole custody is not easy to obtain. And generally that's going to happen if one parent is imprisoned for some reason, or one parent has demonstrated domestic violence and the children have been subjected to it, or any number of situations that could result in sole custody because we're looking at what is in the child's best interest. And we always have to keep that at the forefront of our thoughts when it comes to a divorce. Okay, let's talk income. Now, income is interesting because it can be considered an asset. But when we're looking at income, we're really factoring it in for alimony and child support more than anything else. And when we talk about income and we define it, we're defining it as regular monies received from all sources. So whether it's employment, investments, inheritance, whatever it is, if you're getting it on a regular basis, whether it's because you won the Florida lottery, it doesn't matter. Excuse me, it is still considered income. So if you're receiving an extra $1,000 a month because you won the lottery, congratulations, but that's considered income. And what's also interesting is we have to decide if it's only to you because you won it prior to the marriage, it is income to you. But if you won the Florida lottery during the course of the marriage, then that would actually be an asset of the marriage that has to be divided equally, which would mean both of you getting $500 a month. Now, whether it's received periodically, weekly, annually, it doesn't matter. If it is consistent, regular monies that you're receiving, then it is considered income and gets factored into everything. That brings us to the close of our discussion, which has to do with your future and how we look at your future. So that's a really important aspect of all of this, because you want to make sure that when you're looking at your future, I am so sorry. Let's see if I can get this. When you're looking at your future, you want to make sure that you're considering whether you're going to be in a better position later than you are now. If you're miserable right now, then you're not going to be the best parent that you can be, the best employee, the best business leader, the best anything, because you have all of this doubt. So your choices are go ahead and go to counseling with your spouse, offer to go to counseling, try and work through it, or move toward the divorce situation. Now, you can go ahead and separate if you want to, and you can file for separation and get temporary support for the children that way. So you just have to really think about what's best for you. Now, as we go through all of this, I am actually offering a course that is going to be a set of live sessions where if you're at a point where you want to go forward with an uncontested or simplified dissolution of marriage, what's going to happen is that you can sign up for this course. And if you're interested, please go ahead and private message me on Facebook, or go ahead and message me at DCE Law. Let me go ahead and put this in the chat. www.dcelaw.com, and I can go ahead and get you signed up for that. The cost of the course is going to be $697, and it's going to be 3 sessions, and there will be group sessions. It'll be 3 sessions. And what will happen is I will be walking you through the process of going from point A to point B so that all of your paperwork is completed. Now, that price does not include your cost for filing fees or anything else associated with filing for divorce. That's just the fee for taking the course itself. It's a huge savings. I will tell you that I generally charge a minimum of $2,500 for an uncontested dissolution of marriage or simplified dissolution of marriage. So it'll definitely save you money. And what's also really cool is it will also empower you to see how you're able to complete certain things in the legal profession on your own. So I hope that you have gotten some feedback and some insight with regard to divorce in the state of Florida. Again, please feel free to reach out to me. Go ahead and message me through our website, and then we can go ahead and we can get you set up. Thank you so much for joining us. I don't know if anybody has any questions, specific questions. Make sure that we don't. Okay, I'm going to go ahead and close it down then. Thank you again for joining us, and I wish you all well.